right? They're saying one argument for recusal is, well, Trump appointed her and I tried to shoot Trump, so she's biased. Well, that's not good enough. And given the low odds of this court being assigned 3 cases involving Mr. Trump, some have questioned whether the cases have even been assigned at random. So they're like, oh crap. Well, dude, you shouldn't have tried to shoot Trump. I mean, hello. Like, obviously it's not good. You got like the worst judge you could probably get. It's true. Ryan Routh, the second Trump assassin, would-be assassin, is now trying to get Judge Cannon kicked off his case. He's being prosecuted for multiple crimes there related to his hiding in the bushes and trying to shoot Trump as he turned the golf course corner. He is now in Eileen Cannon's courtroom. And we remember who Eileen Cannon is because she was the judge who dismissed the classified documents case against Trump. And so what is happening here is the defendant, the assassin, Ryan Routh, is trying to get rid of her. He submitted a motion to recuse her and the government is responding. And so let's take a look at what is happening here. This is Ryan Routh's original filing. It says, all right, now it's time to get rid of Judge Cannon. Judge Cannon's amazing. She's the judge, really the only judge in all of the Trump prosecutions who's given him a fair shake at all. So they say, look, in a filing less than 2 pages long, the government opposes Routh's motion to get rid of Cannon, but the government does not even meaningfully respond to what we talked about. Now, curiously, they say that they begin with by stating that this court's discretion to recuse is subject to review only for the abuse of discretion. And so let's back up here. So they're replying to this. So here is the original opposition from the government, and this is the short motion that they're referencing. But they say, look, all right, Your Honor, the government opposes Routh's motion to recuse. This court's discretion to recuse from this matter is subject to review only for abuse of discretion. Cannon doesn't want to go off the case, and the government is agreeing. Let's keep her on. Here, Routh's motion does not cite any authority that mandates you have to get rid of yourself here, Judge Cannon, and does not present either facts or case law requiring a recusal on the record in light of these standards. Judges are obligated to recuse only when there are proper grounds to do so, and Routh doesn't have any of those presented here. Several cases. There's no support whatsoever that a judge can be disqualified based simply on the identity of the president who appointed him, right? They're saying one argument for recusal is, well, Trump appointed her and I tried to shoot Trump, so she's biased. Well, that's not good enough. Some president appointed all the judges, right? Ordinarily, a judge's ruling in the same or related case may not serve as the basis for a recusal motion. Another case example says a judge having been assigned to a case should not recuse himself on unsupported, irrational, or highly tenuous speculation and more. And so in summary, Routh and his motion does not present a sufficient legal or factual basis to disqualify you, Judge Cannon, signed by U.S. attorneys John Shipley. And it's fun to watch this because they just had their entire case dismissed out of Florida under Judge Cannon, and they're not happy about that. They're appealing that in the Court of Appeals. So now Routh is responding, and he explains, you know, this is irrelevant. It's not the standard that this court must evaluate, the abuse of discretion standard. The government's opening and final sentence are misleading. This is not discretionary. Federal recusal laws say that she does need to go, citing some other case law here. Now, indeed, contrary to the government's suggestion, there is precedent here. The government says that Routh cites no authority, but we have some authority. Legally, the government fails to acknowledge that recusal decisions are extremely fact-driven, and they're ignoring this, and they're not identifying anything that is factually analogous to this one. Now, the facts here are unprecedented. That's why there is no analogy. Here's the facts. This is from the defense team for Ryan Routh. They say, to briefly recap, a former president, Mr. Trump, is the alleged victim in this criminal case. Mr. Trump appointed, Your Honor, this judge to the federal bench. This court previously presided over cases where Mr. Trump was a party and issued some rulings that were favorable to him, including one dismissing a criminal case against him while on the campaign trail. Mr. Trump has repeatedly praised this court in its rulings. Mr. Trump would have the authority to appoint Your Honor to a position of power, like the Attorney General, which would be a good spot, were he to be president again, or the Supreme Court. And given the low odds of this court being assigned 3 cases involving Mr. Trump, some have questioned whether the cases have even been assigned at random. So they're like, oh crap. Well, dude, you shouldn't have tried to shoot Trump. I mean, hello. Like, obviously it's not good. You got like the worst judge you could probably get. It's true. Despite vaguely referring to the circumstances of this case, the government does not actually identify them, let alone acknowledge how unique they are. The government likewise asserts in a conclusory manner that the motion does not present proper grounds for recusal, but again, the government does not identify what those grounds are. Rather than directly address them, the government simply cites 3 cases. Contrary to the government's suggestion, the cases don't defeat the motion. So first, the government cites an out-of-circuit case. They say you can't appoint somebody just based on who recuse a judge based on who appointed them. They say we already told you that, but there's much more. Okay, Routh argued that this fact must be considered as one factor. It's not an ordinary situation. Trump nominated her and we tried to shoot him. Rather, Trump is the alleged victim of an assassination attempt. He has a personal stake in the outcome. And in the mind of the public, that Trump appointed Cannon may add the appearance of partiality, given that he has publicly praised Your Honor for rulings in his earlier case, and were Mr. Trump to become president again, he would have the authority to elevate her to a higher position. And second, the government cites the proposition that a ruling in the same or related case is not a basis for recusal, right? If you pass a ruling, you don't have to recuse yourself because of that ruling, you just appeal the ruling. But there is an exception to that rule. More importantly here, nothing precludes courts from considering judicial rulings with other factors. So not only did Trump appoint her, but plus the other rulings. The motion did not argue recusal only on that basis. Rather, the motion referred to the court's rulings in Trump's cases, primarily because Mr. Trump benefited from those rulings, right? So he gave him some benefits. At no point does the government deny those facts, because they probably agree with them. They're like, yeah, we hated her rulings in those cases. They're like, they're right. Now, I disagree, right? I think that her rulings were just, and the defense team is just latching onto this. Like, this is a good defense tactic. Like, this is right. I mean, if you're playing defense on this case, you're making these arguments all day. Like, how can we get a fair shake here? This is crazy. Indeed, the government inexplicably ignores this aspect of the motion because they agree with them. It's not inexplicable. I mean, the defense attorney knows it's very explicable. It's because they're making arguments that they know the government agrees with, but they can't make them here. Third, the government cites the general proposition that an appearance of partiality must be supported by the facts. Mr. Routh agrees. That's why his motion is not based on speculation, but based on facts. Mr. Trump appointed Cannon. Trump has repeatedly and publicly praised her, would have the authority to promote her, and the odds of this court being randomly assigned 3 cases involving Trump were low, which is interesting because ideally we have an impartial justice system in an ideal world. We don't have that at all. Remember, Merchan got multiple Trump cases. Trump's getting hammered with bad assignments in New York, and they say that's just totally random and nothing to scoff at. So why would we be raising concerns here? Anyways, again, the government does not dispute any of these facts. So in short, the government does not accurately set forth any controlling standards. It does not dispute any of the objective and unique facts, and its conclusory response, consisting of 3 inapt citations, otherwise failed to explain why the disputed facts here might create an appearance of partiality in the mind of the public. And there's one new additional matter that Routh, the assassin, must raise. After Routh filed his motion, the government advised defense counsel for the first time that one member of the prosecution's team, Christopher Brown of the Justice Department with the National Security Section in Miami, attended high school with Judge Cannon, and Your Honor attended Mr. Brown's wedding 9 years ago. It's unclear why the government believed that this information was important enough to share with us, but not important enough to include in its response. And it's unclear why, despite hundreds of able prosecutors in this district and around the country, the government elected to staff its team in this high-profile case with the prosecutor who enjoys a long-standing personal relationship with the presiding judge. In the mind of the public, this fact could further add to the appearance of partiality. It's a good motion, and these are from public defenders. I like it. Interesting filing. We'll keep our eye on it. Thanks for subscribing as we do.